This is Bloomberg Law with June Grasso from Bloomberg Radio.
The court is mired in a crisis of ethics. These scandals involving the justices have caused public opinion to question the court's fairness and independence.
The public's confidence in the Supreme Court has fallen to historic lows following a series of controversial rulings that overturned landmark decisions on abortion rights and federal regulatory powers, and determined that former presidents have broad immunity from prosecution. So President Biden, with less than 6 months left in his presidency, is calling for dramatic changes to the court that have no chance of being approved by a closely divided Congress. He's calling for doing away with lifetime appointments to the court, an enforceable code of ethics for the justices, and a constitutional amendment reversing that Supreme Court presidential immunity decision.
We need these reforms to restore trust in the courts, preserve the system of checks and balances that are vital to our democracy. They're also common sense reforms.
Common sense, perhaps, but controversial, definitely. Joining me is William Treanor, Dean of Georgetown Law and a constitutional history scholar. So Biden is suggesting term limits for the justices, a system in which the sitting president would appoint a justice every 2 years, and that justice would spend 18 years on the court. So that would give each president a chance to appoint justices. This is not a new idea. Would it require a constitutional amendment?
No, this is not a new idea. At the start of his administration, President Biden appointed a commission to look at the possibilities of Supreme Court reform. And this is one of the proposals that they made. And they didn't adopt it, they just set it forward. So it's something that people have been focusing on for a number of years. And there's a debate about whether it would require a constitutional amendment. There have never been term limits for the court. So it has always been the case that when people have been appointed to the court, they've stayed their entire life or until they resign. So it would be a new practice in the United States Constitution. And so there's a debate about whether you need a constitutional amendment to do this or not. So I think it should be constitutional because historically the duties of Supreme Court justices have not always been the same. And so this is similarly just altering what the duties of Supreme Court justices would be. But again, that's something that people debate.
Yeah, some argue that the term limits proposal is at odds with Article 3, which provides that justices shall hold their offices during good behavior.
So one of the questions is, is this consistent with the original understanding? And I think it is. One of the changes that we've seen over time is Supreme Court justices are now on the court much longer than they were at the beginning. So if you look at the Washington administration, for example, the average tenure of the justices he appointed was less than 8 years. Whereas now, the most recent departures from the court, either through death or resignation, have been about 30 years. So this is dramatically different than what was envisioned at the start. And it also means that there's a tremendous amount of luck in terms of which president controls the justices on the court. So, for example, Jimmy Carter in 4 years had actually no appointment, whereas in the same period of time, Donald Trump had 3 appointments. So one of the things that Biden's proposal would do is essentially take the luck and the happenstance out of appointments to the court by saying that every president would have an appointment every 2 years. So that really would bring, I think, the makeup of the court much more in line with what people determine in the presidential election. So I think those are really the dominant reasons why I think this would make sense. The terms in office are so long, and it also would bring it in alignment much more with presidential elections.
It seems like there's no chance that this Congress would pass such a law, but let's say a law was passed. Would the Supreme Court then be the ultimate arbiter of whether it's constitutional or not?
So the Supreme Court would ultimately be the arbiter as to whether it's constitutional or not. I don't know kind of where the case that would tee it up would be, but ultimately something like this would be it's a question for the Supreme Court.
Biden is also calling for a binding ethics code that would require the justices to disclose gifts, refrain from political activity, and recuse themselves from cases presenting conflicts of interest for themselves or their spouses. Now, Democrats have been trying to pass an ethics code to no avail. Are there any constitutional problems with Congress passing an ethics code for the justices?
Well, I don't think there's a problem with this. I think that, for example, we have binding codes of ethics for people in the executive branch. It's really the same thing. Congress here would be creating an ethical framework for Supreme Court justices. So it seems to me that it's something that Congress should be able to do. But again, this is something that is debated. And there's some people who will say, for example, Justice Alito has said, this would not be constitutional. So ultimately, this would be a question for the court as well.
That's always the catch-22. Alito claimed in a Wall Street Journal interview that no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. But the Constitution states that the Supreme Court's jurisdiction must be exercised under such regulations as the Congress shall make.
Well, the question is whether this is the kind of regulation that the Constitution has contemplated. And again, this would be a new question. The Supreme Court has never been subject to congressional rules like this. But as a legal matter, the question is, I think, whether this would fall into the Constitution's text about regulation. And that's really debatable. Yeah, I think it would. But again, Justice Alito has said that it would not. And it would ultimately be a question for the court.
I mean, what would it really do? It would stop them from accepting gifts, but it wouldn't do anything to make them less partisan in their decision-making.
Well, the argument would be that when they're accepting gifts, it affects the way in which they think about cases. So it's not partisan directly, but I think underlying the idea of an ethics code is the idea that when you receive gifts, it tends to color your point of view. And so the ethics code would take that out of the equation.
I don't know if he has, made any very specific suggestions, but this would be enforceable by whom?
Well, I think that's a question. So what's the mechanism for enforcement? One of the suggestions that people have had is that you would put together a panel of lower court judges who would decide what's appropriate and what's not appropriate. So it would take it out of the Supreme Court deciding for itself and give it to other federal judges. So I think if this were to go forward, and it's not going to go forward with this Congress, but if it were to go forward in the future, I think that is the most likely framework, that lower court judges would be appointed to enforce the rules.
Then he's calling for a constitutional amendment to ensure that former presidents can be tried for crimes committed while in office. Amending the Constitution is virtually impossible these days. It requires approval from 3/4 of the states. And that means that either political party can block an amendment.
Well, it's incredibly hard, but it's incredibly hard for most of American history. But I think this is really, more than anything else, it does two things. One is it's a symbolic statement, and it's also an indication of disapproval of the Supreme Court's decision in Trump versus United States. So I think it's unlikely that this would be adopted, but it still is a very powerful statement.
Biden didn't include a couple of things that have been proposed at various times, one being packing the court or adding more justices to the court. And that doesn't have the legal problems that his other suggestions have. It's allowed by the Constitution.
That's right. Congress has the ability to establish the number of justices on the court. So right now we have 9, and we've had 9 for more than 150 years. But that's not written into the Constitution, and we've had different numbers of justices over time. So we've had as few as 5, and we've had as many as 10. So there's really no constitutional problem with creating more justiceships. The reason why he didn't do that is that would feel very partisan. So, for example, if you were to have 3 more justices that a Democratic president would appoint, then there would be a taint about those justices. And almost inevitably, the next time you had a Republican president or Republican Congress, it would be expanded even more. So he has proposed something that's not packing the court, but is really designed to be, I think, nonpartisan, to give every president moving forward 2 seats. And on top of that, also to say that the justices on the court will have lifetime tenure. So it will not alter short-term the court's makeup. There's 6 conservative justices, 6 Republican appointees, 3 liberal justices, the 3 Democratic appointees. It would be a very long time before you could conceivably have, under President Biden's formula, a shift towards a Supreme Court in which most of the appointees were Democratic. And in fact, if, for example, Donald Trump were to win in 2024, this kind of legislation would allow him to put more justices on the court. So if he were to serve another term in office and you were to have legislation like this, you would have 2 more Republican-appointed justices on the court, and that would actually shift the court to the right. So the proposal is not one that's partisan. It's really one about establishing a framework for the court moving forward.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Dean William Treanor of Georgetown Law. With less than 6 months left in his presidency, why is President Biden asking for these reforms that have no chance of being approved by a closely divided Congress with 99 days to go before Election Day? President Joe Biden says that extremism on the U.S. Supreme Court is undermining public confidence in the institution, and he called on Congress to quickly establish term limits and an enforceable ethics code for the 9 justices. He also called on lawmakers to ratify a constitutional amendment limiting presidential immunity. I've been talking to William Treanor, Dean of Georgetown Law and a constitutional history scholar. Before the break, we were talking about some of the proposals to reform the Supreme Court that President Biden did not put forward. And one of those is something called jurisdiction stripping, which is allowable under the Constitution.
Right. So Congress has substantial control over the jurisdiction of the court. So at various times in the past, it's taken certain issues away from the Supreme Court. And that's what we call jurisdiction stripping. But that's not something that his provisions or his proposals call for. And I think that's really not been something that has been at the top of the agenda. His proposals really track the things that people are focusing on now. Some kind of expansion of the court, some kind of ethics code, and then also in the wake of Trump versus the United States, a constitutional amendment that would lead to a different result and that would provide that presidents can be prosecuted, which again is before the decision Trump versus the United States. That's been something that has been assumed throughout American history. You know, I worked on the Iran-Contra investigation, and the focus was on whether President Reagan was guilty of criminality. And during the course of that investigation, there was really no argument that you shouldn't be considering presidential criminality. The same thing in Watergate. So this is really, the Trump versus United States decision is something that really represents a departure from something that has been assumed to be the case really all the way back to the times of the founders.
What do you make of the fact that, for example, in Trump v. United States and in several cases where the conservative majority has ignored precedent, taking away the Chevron doctrine, of course, eliminating Roe v. Wade, I mean, do you think that the conservative justices feel no restraint right now, that even the Chief Justice, you know, he used to talk about justices not being politicians. We had Amy Coney Barrett talk about justices are not politicians in robes, but they're making some really radical decisions that paint them as politicians in robes.
Well, one of the things that we're seeing right now is that the Supreme Court is breaking with precedent in major cases. So the doctrine that the court normally follows is called stare decisis, which means once you've decided something, that's fixed. What we're seeing in recent years is the court is overturning a lot of positions that have been well established for a long time. So we talked about the Chevron doctrine. We've seen that also in the context of affirmative action. We saw that in the context of abortion. And the logic of this is, for conservative members of the court, that they're really originalists. They focus on the original understanding of the Constitution. And they're taking the position that if the original understanding says something, then you follow the original understanding, not what the precedent is. So that's why in really important case after case, we're seeing long-established decisions being overturned. Again, Roe, affirmative action, the Chevron doctrine. But they're also not all in alignment. So, for example, the Chief Justice is more respectful of precedent. So in the Dobbs case, he actually was a concurrence. He would not have overturned Roe. So there's a split among the conservative justices on the court about the extent to which they respect precedent.
What's your take on originalism? Because it seems as if you can pick a lot of different things from history, and it just depends on what you pick.
Well, I'm an originalist, and I think that it's very powerful to say that the Constitution should be understood with regard to what the original understanding was. That's what we, the people, adopted. I disagree with the court in a lot of these cases because I don't think they're getting the original understanding right. So in Trump versus United States, for example, I think the founders were clear that a president could be prosecuted. So Trump versus United States is not an originalist opinion. Actually, Chief Justice Roberts, in his opinion, says there's really no obvious original understanding answer to this. There is. So I think in a lot of these cases, you get a very different result if you follow the original understanding, if you, in fact, got the history right. Because I think in case after case, what we're seeing is an originalist court actually is not getting the history right.
During his term, Biden resisted calls from progressives to seek reform to the Supreme Court. Why now, with 6 months left in his term?
Well, I think he wants to make a statement, as his presidency is drawing to a close, that he thinks the Supreme Court is off the rails in a lot of crucial areas. And I think he didn't act before now because this is cumulative. You know, what he's seeing over time is there are more and more decisions in which the court is departing from the original understanding or departing from precedent. And I think Trump versus the United States might have been the trigger for him. That is a decision where I think he would say that the court has taken a position that's really, at odds with principles of the rule of law, and some step has to be taken to address that. At the same time, I think it shows a tremendous amount of restraint because what progressives were pushing for when he came into office and have been pushing throughout is expanding the number of justices. And he hasn't done that. He's gone forward with something that's, I think, both more nuanced and more respectful of partisan balance. It's really much more nonpartisan because it would give to every president 2 appointments for every term. So that's not a partisan result, but it does reflect the idea that you should move away from the kind of 30 years on the court, which is what we're seeing now, and move to something that is much more like, I think, what the founders envisioned.
As you've mentioned, none of these proposals are going to go through this Congress. And even if Democrats won control of Congress and the White House next year, Republicans would still be able to filibuster. So, is there anything that can be done about the Supreme Court, anything practical?
I think statements matter. And what President Biden has done is made statements about term limits. He's made a statement about judicial ethics. And he's made a statement about the Trump versus United States decision. And when he does that, it really alters the dialogue. It brings issues to the fore. So we're talking about term limits. The reason why we're talking about term limits is because of what President Biden has done. And I think that the popular dialogue, I think, does affect the way in which some decisions are decided. So we'll see, moving forward if this has any effect. But again, I think the idea is that it conveys to the court the idea that they have moved out of alignment with, what they should be doing, and that there are very serious concerns that are widespread about the court's path. So, I think it's a long-term effect. It's not going to lead to new legislation. It's not going to lead to a new constitutional amendment. But one of the things that Justice Breyer would say is that the court should not pay attention to the temperature of the day. It should pay attention to the climate of the times. And what President Biden is trying to do is to make a statement about what the climate of the times is.
Republicans have been playing the long game, the very long game, as far as the Supreme Court, which has resulted in this conservative supermajority on the court. And it seems the court has always been more important to Republicans in presidential elections. Are these controversial decisions a wake-up call for Democrats? Will the court now be an issue for Democrats in the presidential election?
Well, I think it will be a point in the presidential election. I think what President Biden has done is to make this issue really front and center. So for many years, Republican presidential candidates have argued, if you elect me, I will appoint justices who will overturn Roe. And that was always the biggest issue. Democratic presidential candidates tried to argue that they would shape the Supreme Court, but it never really got any political wind. So I think that what we're seeing now is, first of all, that there's a real popular movement. And I think it could be a factor in the election. For the first time, I think it could be a factor that would cut in favor of Vice President Harris. She, in particular, she's making abortion a front and center issue. And I think that, that's something that Democrats have not been able to do successfully in the past. So this is the first time, I think, in many years in which concern about the court actually would cut in favor of the Democratic presidential candidate rather than the Republican candidate.
So an Annenberg report on public confidence in the courts finds, quote, the withering of public confidence in the courts. And every poll you see shows that public confidence in the court, whatever the numbers are, they're very low and they're always trending lower. Has there been another time in our history where there's been this crisis of confidence in the courts and in the Supreme Court in particular?
The most prominent time in which there's been a crisis of confidence in the Supreme Court was during President Franklin Roosevelt's administration. And the court struck down many crucial pieces of New Deal legislation. So there was tremendous concern about the court. Now, President Franklin Roosevelt pushed it too far. He tried to pack the court, and that generated a lot of opposition. But that's the period in which, most recently, we've seen incredible concern about the Supreme Court, and I think a sense that it was out of step with popular will. This is a time in which there is a concern about the court in a way that we have not seen for almost 100 years. So the significance of President Biden's proposals is that it's part of a focus on the court, which, again, I think is new within the lifetime of virtually every American.
Dean, thanks so much for your insights and giving us the historical perspective as well. That's Dean William Treanor of Georgetown Law. Coming up next on the Bloomberg Law Show, Nike fires a warning shot to sneaker artists. I'm June Grasso, and you're listening to Bloomberg. A sneaker artist known as the Shoe Surgeon built a customization empire, collaborating with global brands like Nike, Gucci, and Adidas, and a cult-like social media following. Justin Bieber, Drake, and Odell Beckham Jr. all wore his customized shoes, and he's even started an academy where students pay up to $5,000 to learn the craft of shoe personalization. But not so fast. Nike is suing Dominic Chambrone for trademark infringement and counterfeiting and asking for $60 million in damages. Joining me is Zak Kurtz of Sneaker and Streetwear Legal Services. So, Zak, I'm going to confess right up front that I don't know much about the sneaker world. Who is the Shoe Surgeon?
The Shoe Surgeon is the guy in the industry of sneakers and customization of sneakers. His name is Dom Chambrone. And he started sort of as a bespoke cobbler, just doing one-of-one customs. And he still continues to do that. It's just he's got a bigger clientele now. He was actually in Entourage, I believe. He's also done shoes for LeBron James, Drake, Justin Bieber, OBJ. I mean, you name it. All the celebrities really want to work with him now. So if you're familiar with jewelry and watches and people say Jacob the jeweler, he's sort of that version in sneakers. He's the guy to go to in customs and really leads the industry in sort of creativity and custom footwear and custom apparel. He's even done stuff for Logan Paul when he fights in the ring. He does all of his equipment and his boxing shoes as well.
Nike hired him several times between 2017 to 2023 to customize shoes, and once commissioned him to create a pair of sneakers for LeBron James encrusted with 24-karat gold and $100,000 worth of diamonds. Those are some sneakers. But now Nike is suing him. Why is Nike suing him?
Essentially, they're saying those collabs that you mentioned, there was one in 2017, 2018 for the LeBrons that you mentioned, and then another time in 2023 where he did another pair of shoes for LeBron James for being the all-time leading scorer passing Kareem. So he's been on Nike's good side, and they've done a whole bunch of deals with him. But for whatever reason, they decided that what he's been doing now, such as, creating these customs and opening up his own surgeon academy where he's teaching others to customize sneakers, they thought that that was a little too far, and they're claiming that it was without their approval and that he should have known that.
Customizing sneakers, is there any problem with intellectual property rights if you customize a brand sneaker?
I guess there are people on both sides of the coin there. I believe that the answer is no. I think that the first sale doctrine essentially allows you to resell or customize even another brand's trademarks legally. There are a few exceptions to that, specifically, if it's materially altered. And that's one of the areas that these custom sneaker cases come down to, if it was materially altered enough. And, there's case law on that, and it really doesn't require too much to be materially altered. But the way I see it is this is really just a form of expression, of creative expression. And if I purchase a pair of shoes and I want to color on them, and if someone does a better job coloring on them than me and I pay them for that service, there was really nothing wrong. There should be no trademark confusion. I know what I'm doing. I know who I'm doing it with.
But is Nike saying more than that? Is Nike saying that he's actually created counterfeit Nike sneakers?
They are. They're saying, one, that they're these infringing new shoes, and they're claiming that those are customized shoes, meaning someone purchased a valid, authentic Nike shoe, and they're using, the base of an authentic Nike shoe, and then customizing the rest of it and making their own. Second, what Nike's saying is these are counterfeit Nike shoes. It's a Nike shoe entirely from scratch.
Let's take those one at a time. Let's take the counterfeit. That's clearly illegal, right?
Yeah, to me it is, and that's where I think this case lies, because I know a lot of people in the sneaker industry, and I even have customs myself, and, most of the time when you're doing that, you're starting with a base, you're starting with an authentic Nike bottom or an Adidas bottom. You have to get that mold of that bottom because those molds cost a lot. It's hard to just buy authentic, molds and such from China, and to your point, that would be counterfeiting. But I don't think that's what's going on here. I think, these are still authentic Nike midsoles and soles that they're using, and they might change up some other things there that turn it into a custom, which is that first sect we talked about.
I mean, do you have a question in your mind about whether they're accusing him of also making counterfeit Nikes from scratch?
They definitely are. I'm saying that, based on my knowledge in the sneaker industry, and I don't think that that's what's going on here. But Nike is claiming that the second aspect of counterfeit Nike shoes entirely from scratch, according to the complaint.
Is Nike saying that he needed the company's permission, that they've partnered before, and that should have put him on notice that he needed Nike's permission?
You're right. There was a part in the complaint that discussed exactly that, the fact that previous agreements sort of showed him the way to work to Nike, and that he should have known that these other ones are outside the limit. However, the way I see that is they talked in the complaint about how they allowed these one-of-one customs and these smaller kind of services and stuff as well. And I sort of see that as the same kind of thing here. If you're allowing those and then you're working with Nike after that, then, there's sort of the same thing. If you're just giving it to the same person, the lines can be blurred, and I could definitely see both sides. But yes, Nike's definitely alleging that the previous agreements, he should have known that he needed Nike's permission.
The first sale doctrine, has that ever been tested with sneakers in court?
Yeah, there actually are a couple of recent cases. There's a case where Vans sued Mischief, which is a Brooklyn art-based collective that also creates sneakers and other products. And they sort of just make fun of big businesses and do a lot of real good First Amendment kind of free speech and parody kind of stuff as well. And in that case, they made a shoe that looked very similar to Vans' old school, famous black and white skate shoe, except it was distorted. It was called the Wavy Baby, and it went up and down, and it was really something comical. And it even had disclaimers on the bottom of the shoe that said, don't walk in this, you'll get hurt. And, they thought that they would have been protected by the First Amendment or the first sale doctrine. And they raised both those defenses in that case, and ultimately they ended up losing, and they're actually in appeals right now. I believe the appeal court sided with Vans as well. For the first sale doctrine, there's a bunch of other ones that raised the first sale doctrine recently in counterfeiting kind of cases. I know John Geiger, and there's another case called Nike versus Customs by Aline, and that would be more applicable here, I think, because they sort of did the same thing. They used Nike shoes and they painted butterflies on them and did their own custom art, and they sold them. However, in that complaint, there are documents and evidence that these people were purchasing fake Nike shoes and not Nike shoes. A similar first sale defense was raised in that one, and that one ended up settling, so we didn't really get any precedent on it. But they had a similar defense, and they did customs, except with that one, it was unauthentic Nikes that they were allegedly using.
What about his, this academy where he's teaching people? What is he actually teaching them there? Do you know?
He does a bunch of academies. He has one in L.A. and one in New York, and there's also even online classes. And essentially, he's really just teaching the people how to be customizers themselves, how to make a shoe. And in order to make a shoe, you got to do decon and recon. So essentially, they're taking apart shoes and building up new shoes. And Nike, in the complaint, was alleging that this was an illicit empire of infringement. He was teaching people to, infringe on Nike trademarks, when I think that's very craftily worded by their lawyers. Essentially, there are all these kind of sneaker customization shops and sneaker education classes out there in the world. That's essentially what he's doing. He's just teaching you how to build up a shoe and rebuild a shoe. It's just sometimes he's using a Nike shoe as an example.
Looking at this from outside the sneaker world, if he's showing people how to take a Nike shoe apart and then make another shoe from the Nike base, that seems to me like it's infringement.
Not necessarily. There are a lot of factors that go into infringement. And, actual confusion is one of the big ones. And, if you're purchasing a class from him for whatever the price may be, from $500 to $5,000, and you're building a shoe yourself, you're not going to be confused. You know what you're doing, and you're building your own Nike shoe. And most of the time, you're keeping that for personal. You're not reselling that or anything. So I think there's arguments to be made about actual confusion, and he's just so big in the industry that people know who he is. And on his shoes and in his class, it has his trademark logos and, everything that he uses as well. So I think those are also other factors that help, avoid any type of confusion. And that's really one of the most important things here. Trademark infringement and trademarks in general are just meant to be source indicators. And that's sort of what Nike's saying here. They're saying that, when he makes his shoes, people are confused if it's a Nike or a surgeon. And, his name is just so big in the industry now. So if you see his logo on the shoe, then you're going to essentially know it's a custom shoe, which is different than, a regular Nike shoe. And it's a form of expression.
But the court that heard this, the one case, didn't agree with that.
Exactly. That case was a little different and such. But, yeah, people equate this to cars. If I buy a Honda and I put a mod kit on it, is Honda going to come after me and say, hey, you can't do that? And there are some companies that actually do go after people for similar kind of things. Famous is a Ferrari case. It didn't get litigated, but there's a DJ named Deadmau5, and he put a rainbow kind of graphic effect on one of his Ferraris, and he used it everywhere he went. When he went to parties, and it got named the Ferrari, just because there was a cat on the side of it. And Ferrari didn't like that, so they sent him a cease and desist, and they essentially said, don't use it anymore, take it apart, or we're going to come after you. And he listened to him. He ended up stripping all the decals and selling the car. And there are other cases that actually have been litigated that's sort of similar. So it's just crazy to hear, the kind of reach or control that these companies have on their products aftermarket.
And the sneaker surgeon is putting his own trademark on a Nike shoe.
Yeah, most of the time he is. But to your point, that sort of helps eliminate confusion by people seeing that logo and saying, oh, I know who this is, the shoe surgeon shoe, which means it's going to be a custom shoe. He doesn't just do Nikes, he does other brands as well, Adidas, New Balance, you name it, he does it. And to me, again, it's a form of expression. I have many custom shoes, and I've really just reached out to those guys and said, hey, can you create this for me? And it's sitting on my desk right here, right now. And
Sneakers on the desk. It really is not my world. So do you see this suit going to trial, or do you see a settlement?
Sneaker customization is something that's there, and it's not going away. Customization in general is so big in every industry. Everyone wants to, show off themselves and their form of expression, whether it's athletes on the field or the court or wherever it may be, or, just people like you and I. So I think the customization thing is never going away, and I think that Nike has embraced it. They've been doing deals with customizers such as the shoe surgeon. So it would be crazy to see that end. I don't think, that's going to happen. I think Nike, in their statement and even in the complaint, they sort of carved out a lane for these customizations to be done. And that's sort of what this is about, how big the shoe surgeon's lane is going to be.
So, what lane do you think they've carved out?
So they talked about allowing specific one-of-one customizations for, Nike-sponsored athletes. And I think that's important because, these athletes probably have clauses in their contract that say you can't do this or you can't do that, or you got to come to Nike with permission. And if they're doing a custom, whether it's, one shoe for themselves that they're going to wear during the game or just shoes they're going to wear around town, Nike's going to be aware of that. And, that's really what Nike wants here. They want to know what's going on so that they're not left out, and they check everything to their exact specifications like they claimed. So I think those kind of collaborations and customs will be allowed. It also mentioned in the complaint that they're happy with the shoe surgeon when he was just doing small-time work as a, bespoke cobbler, one-of-ones and such. So I think, by putting out that in the complaint, then it sort of also opens up a lane as well.
I've learned a lot about the world of custom sneakers. Thanks so much, Zak. That's Zak Kurtz of Sneaker and Streetwear Legal Services. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.